All right, everyone, welcome. We appreciate your time this afternoon. This is our fourth and final 2015 webinar about the Support Anti-Terrorism by Fostering Effective Technologies Act, the Safety Act of 2002. And we appreciate you taking the time out of your busy schedules to spend some time with us, and we hope you all enjoyed a wonderful Thanksgiving last week. Today's webinar is designed to help the Safety Act process those already familiar with how the program works, as well as those of you who are just starting out. It's a webinar that's also important to us at OSAI. Today we're going to talk about what Safety Act protections really mean for you, for your customers, and for all the people in your supply chain. In previous webinars we talked about content of the types of applications we needed. Today we'll talk about some of the practical implications of Safety Act protections and hopefully help you explain the Safety Act to your management, your suppliers, and your customers. Before I get started, I'd like to address the administrative details. So if you're having trouble with the audio on your computer, you can always dial 1-517-308-9417 and use participant code 2371042. The information is all on the left-hand side of the screen for reference. At the end of the webinar, the slides we'll be using today will be available for download in the meeting session in the upper left-hand corner. It's the file called Safety Act and Business Webinar. The audio for this webinar will be available for download at www.safetyact.gov in the near future. And if you're new to the Safety Act process, our previous webinars, slides, and audio are viewable on safetyact.gov, and you can also find us on YouTube. Finally, if you have specific suggestions for future webinars, please let us know by sending an email to safetyacthelpdesk@dhs.gov, or let us know at the end of the webinar in the chat room. So I'd like to turn it over to Andrea Schultz, who's the Deputy Director of the Office of Safety Act Implementation, for sort of a state of the program address and a welcome and kind of set the stage for today.
Thank you, Laura. First, I'd like to welcome everyone to our webinar today. It's really great to have so many of you join us as we enter such a busy time of the year. I can see a lot of people have logged on, and I know we have more on the phone. In the Safety Act office, because we're on the fiscal year, I wanted to give you an update of our fiscal year 15 totals. Through the support of DHS leadership and through you, our industry partners, protections were granted to 87 technologies in fiscal year 15. That's a 33% increase over what we did in fiscal year 14. This also supported over $7.5 billion of technology revenue and over 151,969 employees. So that's a lot of jobs. As the Safety Act continues to grow, we want to make sure that everyone with Safety Act protections knows how to explain what those protections mean. And we also want those who are considering seeking Safety Act protections to be able to explain the importance of these protections to their managers and their shareholders. Also, I recently attended a couple conferences, and I walked the trade show floors. It was really exciting for me to see so many technologies that I knew had earned the Safety Act protections. One of the things I was a little puzzled by was that I didn't see the Safety Act trademarks that often for designation or certification. So that's one of the reasons why we want to talk to you today. Our team wants to make sure you understand what's available to you in promoting your Safety Act protections to your customers and to other people. Office of Safety Act implementation staff members will be available to address specific questions in the chat room during the webinar. We already have a few people logged on. We will also have some time at the end to address some of your pre-submitted questions. And if you have questions, you can also dial in and ask those. If you come up with questions later, you can also contact the Safety Act Help Desk, the phone number and email address that Laura gave you already, and they'll also be at the end. So I'm going to turn it right back over to Laura now.
Great. Thanks, Andrea. And be remiss if I didn't introduce Meenal Patel right up front. We'll be talking to Meenal in a little bit. But I want to set the stage a little bit because I'm happy to be helping out at this webinar because after the last 10 years, I really like to talk about the Safety Act. And I really want to help others be able to do so. So when I started with the Safety Act program, one of the most difficult challenges I had was explaining why the Safety Act was so valuable. I intuitively knew that it was, but having to explain it was challenging. So I practiced. And I'm not sure I got really good at it until a couple of years ago when I started having to explain it to my rapidly growing nieces. So I broke it down to the basics for them. The Safety Act is about helping businesses who are selling solutions that work to keep us safer. It helps them protect themselves if bad things happen. And one of my very astute nieces, the oldest one, asked what a solution was, of course, and I went on from there until one of the little ones chimed in with, "Oh, so you help make sure that the things firemen use are good so that they don't get hurt, and we don't get hurt, and the people that make them don't get hurt." And I smiled and nodded because for a 6-year-old that was pretty good. It got right to the heart of the matter, and then I bribed them with ice cream. But my niece had really broken it down to its core. The Safety Act is really about companies, people that make things, customers, people that use things, and the public at large, everyone who benefits. But as they get older, my nieces, all 10 of them, and one nephew now too, will hear Aunt Laura's speech, which is, as part of the Homeland Security Act of 2002, Congress enacted several types of liability protection for providers of anti-terrorism technologies. That's the central purpose of the Safety Act. The Safety Act provides incentives for the development and deployment of anti-terrorism technologies by creating systems of risk management and litigation management. The reason for the Act is to ensure that the threat of liability does not deter potential manufacturers or sellers of anti-terrorism technologies from developing, commercializing, and deploying technologies that could significantly reduce the risks or mitigate the effects of large-scale terrorist events. Thus, the Act creates certain liability limitations for claims arising out of, relating to, or resulting from an act of terrorism, where qualified anti-terrorism technologies have been deployed. The Act does not limit liability for harm caused by anti-terrorism technologies when no act of terrorism has occurred. For the purpose of the Safety Act, an act of terrorism is any act that the DHS Secretary determines meets the requirements under subparagraph B of Section 4442 of the Safety Act, as such requirements are further defined and specified by the Secretary of DHS. The Act meets the requirements of subparagraph B if the act is unlawful, causes harm to a person, property, or entity in the United States, or in the case of a domestic United States air carrier or United States flag vessel, or a vessel based principally in the United States on which U.S. income tax is paid and whose insurance coverage is subject to regulation in the United States, in or outside the United States, uses or attempts to use instrumentalities, weapons, or other methods designed or intended to cause mass destruction, injury, or other loss to citizens or institutions of the United States. In any case, the Safety Act would not apply in the event of a natural disaster. It's not an all hazards program. Further, the Safety Act is not a regulatory program. Your participation is completely voluntary. But because we are non-regulatory, we also don't publish specific requirements. We evaluate your technology for demonstrated effectiveness. We also aren't a test entity. While we ask for test data, we don't have the resources to conduct tests of your technology or provide grant money for you to test your technology. So we're going to move through and talk a little bit about some more background before we turn it over to Andrea and Meenal. But today our discussion focuses on what happens after you have been issued Safety Act protections. But if you have questions about the application process and the type of information we look for, please check out our other webinars on safetyact.gov. But first, we're going to discuss one of the most important terms of all, the seller. Who is this mysterious seller I talk about? Well, that's you. We'll talk about what that term and who is identified as the capital S seller and what that means for you legally and practically. Then we're going to delve into the similarities and differences in the protections available through the Safety Act. Meenal Patel from the Office of General Counsel here is going to help us understand the protections, what they do and what they don't do for you. So once you understand the legal implications of the Safety Act and those protections, we'll talk about the protections, how they affect your suppliers, your vendors, your subcontractors, or also your upstream providers. We'll also talk about how your designation or certification can protect your customers, sometimes called downstream protection. Meenal is going to help explain these protections as well. So thank you, Meenal. We appreciate you joining us this afternoon. So then once we understand the legal protections a little bit better and the restrictions and any impacts of Safety Act designation or certification, we'll help you figure out how to tell your customers and suppliers or subcontractors in plain English what the Safety Act is all about. Lastly, we're going to briefly cover what you'll need to tell us after you've received your Safety Act letter. And this is just a reminder about your insurance limits and the terms and conditions for using those Safety Act marks that Andrea mentioned, and any changes to your technology that you might want to let us know about. So I'm going to turn it back to Andrea, who's going to talk a little bit more about who is the seller and what is this seller thing that's so important to the Safety Act.
Yeah, we're not talking about the basement.
Yeah.
So thank you, Laura. Today we're going to use the term seller a lot. For the Safety Act, the term seller is used intentionally, and it has very specific legal implications. According to the Act, the seller is any person or entity that sells or otherwise provides a qualified anti-terrorism technology to federal and non-federal government customers. That doesn't really give us a good idea of what the seller means. Let's take a look at the final rule that the Department of Homeland Security issued about how to implement the Safety Act. That defines the seller as the term seller means any person, firm, or other entity that sells or otherwise provides the qualified anti-terrorism technology to any customer or customers, and whom or to which, as appropriate, a designation and or certification has been issued under this part, unless the context requires otherwise. I don't know if that made it any clearer. Maybe not. In the application kit for full designations, there are two places to identify sellers: in the registration information and in item D7, additional sellers. The first sellers refers to you as the provider of the technology, and by the very act of filling out the application, you're the seller. Your company's name will be the official seller on any designation, certification, or insurance certificate for the Safety Act. Well, that seems a lot less complicated. We know it isn't always that simple. Sometimes the company filling out the application is a subsidiary of another larger company, or you may have subsidiaries of your own that also distribute and sell the technology. For example, on June 22, 2015, the Secretary issued Safety Act protections to Securitas AB, Securitas Holdings, Inc., and a number of its subsidiaries and affiliates. Each of these entities is a seller and is entitled to not only the protections of the Safety Act, but each is also responsible for maintaining the level of insurance prescribed in the designation and certification. Now, some of you may have a partnership or a subcontractor who is an authorized reseller or distributor of your technology. These folks are also eligible for some of your protections, but they are not identified as the seller with respect to the Act. We will be talking about what your protections mean for them in just a little while. Meena Patel from our Office of General Counsel is going to explain that part a little bit further.
Thank you, Andrea and Laura. I'm excited to be here today. Applicants, especially novice ones, routinely ask who exactly should be listed as the seller and how do I determine if I have additional sellers. A good rule of thumb is to focus on the anti-terrorism technology. That's the subject of the application. Ask yourself, which entity is legally responsible for this technology? In other words, if the technology causes injury or death, who's likely to be sued? When thinking about this question, contact your general counsel's office and your risk managers, as they may have some insight into some of the finer distinctions about which corporate entity in your company structure is exposed to liability. Another question to ask yourself is which corporate entity is primarily responsible for the quality control, the management, or the integration of the anti-terrorism technology. Responsibility usually tends to equate to liability in litigation. Not always, but it serves as a good indicator of which entity is exposed to liability.
Great, wow, thanks. I think, Andrea, it's back to you.
Yep, so let's touch a little bit on the protections offered by the Safety Act. The Safety Act has two primary levels of protection: designation and certification. There's also a subset of designation called the Developmental Testing and Evaluation Designation. We like to call it a DTED around the office. DTEDs apply to technologies that need additional testing or pilot deployments. They've typically reached a technical readiness level of about a 6. Designation applications are for those technologies that have information on technology performance. How does it work? How do you know that it works? While certification applications are typically supported by a track record of performance. It's worked reliably over a period of time. How do you know that you can deploy it across multiple locations and other things like that? Other types of applications, such as in response to a block designation or certification posting, or those related to procurement qualification designation notices, typically relate to very specific technologies. If you think those apply, please contact our office and we'll help you figure that out. Also, if you're a federal, state, or local procuring entity seeking to submit a procurement pre-qualification request, that's hard to say, contact our office. I'm going to turn it back to Laura now to discuss the nuances of designation.
Okay, great, thank you. Designations are, as Andrea mentioned, for technologies that have demonstrated effectiveness during operational testing or prior operational use. Designation provides a liability cap as well as exclusive action in federal court, no joint and several liability for non-economic damages, and no punitive damages or prejudgment interest. The seller, named in the designation, is the sole entity that can be sued for third-party injuries in the event that the technology fails in an act of terrorism. This protects all of the companies and persons involved in the provision of the technology. We sometimes refer to these protections as upstream if we're talking about a vendor or supplier you use to procure the components of the technology. This might also be a subcontractor who assembles parts of the technology or provides training to your personnel who are providing the service. So if there's an upstream, there must be a downstream, right? When we talk about downstream, we're typically talking about your distributors, subcontractors, or other entities who provide the technology to your customers in your stead. We'll talk more about this just a little bit later in the webinar. This was just a teaser. Now, what if your end user or your customer misuses your technology or does not keep it properly maintained, or appropriately train all of their people and someone else gets hurt? This is the responsibility of the customer. Your customers will get some protection from your designation, but they are responsible for any claims of negligence on their part. If a technology receives designation, the applicant is required by the Safety Act to obtain liability insurance in the amount specified in that liability cap section of your designation letter. You must maintain that level of insurance throughout your designation. This is usually a cooperative process between you and DHS in some cases when insurance is not available. You might have the option to self-insure, and that's something we'll probably touch on a little bit later. A designation and then its associated certification normally lasts for 5 years, after which time both can be renewed. And just a plug, we'll be talking about that more in January or February. Any technology deployed during its time period of designation is protected for the lifetime of its deployment. I know I've thrown a lot of terms out there, and some of them are pretty technical, legally speaking. So let's talk about what some of these terms mean in plain English for all of you non-lawyers out there. I couldn't pass my LSATs if I tried, because now I'm an engineer, and I do use technical terms like gunk and crud. And sometimes we even talk about widgets and thingamabobs. But these legal terms, all Greek to me. So we really need to have more help from Minal. She can explain what these words really mean for you and me. So Minal, when the law says exclusive action or exclusive federal jurisdiction, I have no idea really what that tells me.
So the statute and the final rule, they refer to this concept, exclusive jurisdiction, and they refer to it as one of the benefits of obtaining Safety Act protections. The concept includes 3 specific principles. There is only one cause of action for all losses of property, personal injury, or death for the performance or non-performance of a seller's technology. 2, that the seller is the only appropriate defendant in such a lawsuit. And 3, the lawsuit must be brought in federal court. So let me talk about these principles individually. Principle number 1 stated that all claims for losses of property, personal injury, or death associated with your technology must be brought under one cause of action. So what does that mean? Basically, the intent of the statute is to have a seller defend itself against one lawsuit instead of multiple lawsuits. This is intended to streamline litigation for sellers of Safety Act protected technologies. Principle number 2 essentially stated that only the named seller is the appropriate defendant, and this effectively protects the seller's suppliers and the seller's customers. Some of the downstream and upstream entities that Laura was alluding to earlier and that we'll discuss further later in this presentation. Principle number 3 is if you are the seller and you're sued, the Safety Act, and if the Safety Act protections are applicable, then a federal court is the only court that has jurisdiction to hear your case. So what that means is you can't be sued concurrently in state court for these claims. This is really important benefit for sellers. Without Safety Act protections, your company may be sued in federal court or in state court or maybe even in both courts. It can become very complicated. The intent of the Safety Act was to undo some of these complications or to mitigate some of these complications. Litigation is complicated, it's messy, it's costly, it's time-consuming. Each of the principles above is intended to address some of the more complicated aspects of the litigation to help sellers. Basically, the Safety Act intends to make litigation less complicated by limiting the number of cases a seller defends itself against, by limiting the number of defendants in one litigation, and by limiting the courts where the seller can be sued. This provides some level of certainty and cost savings for a company and its general counsels and risk management offices.
That's really great. You know, after 10 years, that finally makes more sense to me. Thank you. So as the seller, right, I'm the defendant, and anyone who sues me is the plaintiff. Is that right?
Yeah, that's basically right. In the past, some of our applicants have asked, well, wait, if the seller is the only entity that can be sued, then why would I want to be the seller? That means I'm going to be the one that's sued. That's a valid question. Many companies recognize that due to the specific technologies and their role in developing and deploying the technologies, they're the most likely entity that will be sued. So whether you had Safety Act or not, your company will probably defend a lawsuit in the event that something were to happen. Therefore, this company tends to seek Safety Act protections to consolidate all those claims being brought against them and to benefit from the protections afforded under the Safety Act, such as limits on punitive damages, limitations on non-economic damages, and limits on liability.
That's great. So another one that always trips me up is, what is this joint and several liability thing? I understand what liability means, but joint and several, does that mean there's several kinds of liabilities? Or how does that term seem to work with exclusive, it's joint, it's exclusive? I got nothing.
This is a great question. So I'm going to try to break this down into manageable sound bites and digestible bits of information. In traditional litigation, defendants can be liable for a lot of different types of damages. For example, there's direct loss damages, such as property loss. And then there's personal injury damages, such as death or injury of a person. Non-economic damages, which means pain and suffering, inconvenience, mental anguish of an injured person or of a loved one. There's also something called punitive damages. These type of damages, they're not intended to compensate a plaintiff for actual loss like the other damages were, but they're instead there to punish the defendant for doing something wrong in the eyes of the court. The Safety Act limits plaintiffs' recovery to damages that compensate a plaintiff for actual losses, loss of life, injury, damage to property, plaintiff's non-economic damages. For any claims where the Safety Act is applicable, a court may not award punitive damages against the defendant. So a defendant won't be punished for not doing something or not taking an action. Also, a plaintiff has to have suffered actual loss to recover for non-economic damages. So, for example, a person who sees an event but sustains no injuries or damage to property can't recover for mental anguish for just seeing that event happen.
Wow.
That's a lot of talking,
Wow.
I know. And I haven't even mentioned the words joint or several or liability, any of the words that you mentioned in your question. So we have all these damages, these different types of damages. Where does the liability come in? Well, these damages can be apportioned or divided up amongst multiple defendants, or even amongst one defendant in multiple ways. There's joint liability, there's several liability, and then there's something called joint and several liability. Under joint liability, each defendant is liable for full judgment amount, and the plaintiff can collect the full amount from any of the defendants. Under several liability, each defendant is liable only for their portion of the judgment, which is usually proportioned to the defendant's negligence. Under joint and several liability, each defendant is jointly responsible for full judgment amount to the plaintiff. The plaintiff may collect the full judgment amount from any of the defendants. If one defendant pays the full judgment amount, then the defendant may then collect portions of the judgment from the other defendants. That is a lot of legal talk. I just heard myself in my head. So what does this actually mean? I think the best way to explain this is an example. So joint and several liability is A sues B and C, and the court awards a judgment where B and C have joint and several liability. A can collect the money for the judgment from either B or C or both. If A collects the full amount from B, then B can try to recover the portion that C is responsible for from C. The bottom line is that in joint and several liability, one big defendant may have to pay for all the small defendants for the simple reason that the big defendant has the resources to pay that amount. Under the Safety Act for non-economic damages, the defendant is only liable for the amount of damages directly proportional to the percentage of the defendant's responsibility for the harm to the plaintiff. This is the complete opposite of joint and several liability, which is a real benefit for the sellers, as the sellers will not be responsible for more than their share of the non-economic damages. See, in the past, during the 9/11 litigations and the 93 Trade Center bombing litigation, the courts apportioned responsibility for damages between defendants that were being sued and the terrorists who actually carried out the attacks. So the defendants weren't liable for the full amount per their proportional responsibility. For claims related to an act of terrorism under the Safety Act, a defendant is only going to be liable for the non-economic damages that was proportionate to the percentage of the responsibility that the court said they were responsible for, and not the full 100%. So then who pays for the rest? It's probably going to be no one. That was a lot longer than a soundbite. Hopefully digestible nonetheless. I think I just gave you a Thanksgiving Day feast here. I'll try to portion control the next few responses a little bit.
Thanks. Well, you mentioned those non-economic damages and the proportionate to my responsibility. So what do those mean in the context of an act of terrorism or somehow that I might be implicated with my technology?
So essentially, if you're sued and the Safety Act protections are applicable, then you may not end up paying the full judgment amount for the non-economic damages.
Okay. All right. Wow.
And this portion of the Safety Act is really great for you to have further discussions with your in-house counsel and to really utilize your general counsels when communicating the benefits of the Safety Act to your principals and your executives in the company.
Absolutely. I mean, I always focus on the liability cap, but it seems like there's some great legal protections there. So what about this punitive damages things? Because I just read in the news that this guy from Illinois was given $16.5 million in punitive damages after being injured by a sliding door. I really don't even want to know, but I also don't want to know or have something like that happen to me in my technology, right?
Yeah, so remember, punitive damages is damages where the company is being punished for this action that they didn't take, that the court thought that they should have taken. The Safety Act completely bars punitive damages, meaning the defendant may not be found liable for punitive damages.
All right, great. Well, thanks for cleaning that up. I think we're down to the last term that I always really struggle with, which is this concept of prejudgment interest. And I really just, nothing.
So in certain litigation, defendants may be liable for interest that accrues on the amount of the judgment from the time that the injury or damage occurred up to the point where judgment is entered. So think about this in real terms. When an injury occurs, the plaintiff is injured, then there's a couple months go by, then they decide to sue, then a long litigation ensues. During that whole time, you could be collecting interest on that judgment amount. What the Safety Act says is it prohibits these type of prejudgment interest.
Great. I'm feeling a lot better about being able to explain this the next time I have to talk to anybody in my family, maybe over the holidays. I think Andrea right now is going to talk a little bit more about certification, and then we might have some more legal questions.
Yep, I think holidays at Laura's house are going to be a lot of fun. So, certification as an approved product for Homeland Security. Thanks, Laura. Meenal, you really cleared a lot up for me. I read all this, and it didn't click until you just went over that, so I really appreciate that. Let's talk about certification for a second and see where technologies that have a high level of technical maturity and a history of deployment and use, certification might be appropriate for you. Technologies that receive certification will also be placed on an approved products list for Homeland Security, which really just basically means we're going to publish a brief overview of your technology on our website, www.safetyact.gov. In the Office of Safety Act implementation, we conduct a comprehensive paper-based review of your technology. The questions for certification request more detailed information regarding your technology's performance over time. It's compliance and adherence with your specifications and its proven record of safety. The bar for certification is higher than it is for designation, which is why more information is considered in the evaluation process. In addition to the benefits provided under designation, certification allows a seller of anti-terrorism technology to assert the government contractor defense. It immunizes sellers from liability for claims arising from acts of terrorism. However, you as the seller must have designation in order to be even considered for certification. That's where we mean by saying designation is a prerequisite for certification. You must also maintain the level of liability insurance specified in your designation. That is, in order to keep your certification, all the responsibilities you have regarding your designation need to be met. If you let your insurance lapse or fall below the specified level, you may lose your designation and certification protections. Certifications are valid for the term of the corresponding designation and can be renewed. Laura mentioned that earlier. I think we can make it a little bit simpler though. Laura, what do you think?
I certainly hope so. You know, as my nieces get bigger, I think the questions just keep getting more and more technical. So we've talked a little bit about the benefits and the responsibilities that come with Safety Act certification. And I'm going to rely on Meenal to help us again here, which is, you may have heard of that government contractor defense thing that, you know, I was sort of following orders sort of argument. Well, Congress intended for that type of argument to apply to the technologies that are certified under the Safety Act. But what if I'm not selling my technology to the federal government? Meenal, how does the government contractor defense work with Safety Act protections then?
Yeah, so under the Safety Act, a seller may utilize the government contractor defense even when the technology is sold to non-federal government entities, including the private sector. Additionally, the Safety Act states that the Secretary will conduct a comprehensive review of the design of the technology and determine whether it will perform as intended, conforms to the seller's specifications, and safe for use as intended. The information that our offices routinely request in a certification application is information that would support these three categories, kind of the long-term effectiveness of the technology.
So in that comprehensive review and all that information that the seller submits in the application would support the government contractor defense. That's great. What about the requirements for maintaining the liability insurance? I mean, I have designation, so why do I really need to do that?
Yeah, so even when a company has certification, a company is required to maintain the liability insurance that the designation had, because there's a limited circumstance in which the applicability of the defense may successfully be rebutted. In that case, the seller would not be able to use the government contractor defense, and they may become liable for the damages that the court finds. The Act specifically says that the presumption of the government contractor defense that the government contractor defense actually applies may be overcome only by evidence showing that the seller acted fraudulently or with willful misconduct in submitting information. Meaning, if a plaintiff shows that a defendant intended to mislead the department with the information that the defendant provided, or even possibly did not provide certain information, the plaintiff may be able to successfully keep the defendant from utilizing the government contractor defense. And in that case, we would want insurance to be responsive.
Wow, great. I never realized that nuance, so thanks, Meenal. That really actually helps clear things up about me, for me. Now, we have this other type of protection, these developmental testing and evaluation designations. So I think Andrea is going to talk a little bit about those and see if we can distill that.
Sure, no problem. Some technologies, we like to use the developmental testing and evaluation designation if we think something's really cool. So some technologies show a lot of promise, but maybe they're not mature enough to be fully operational. The developmental testing and evaluation designation, or DTED, like I said earlier, is available to provide protection during that testing or trial deployment so that you can collect the data that you need to show us that you have an effective technology for when you apply for full designation. DT&E designation provides similar liability protections that are provided by full designation, but there are some limitations and there are some constraints. So in general, developmental test and evaluation designations will include limitations on the use and deployment of the subject technology, subject to a termination at will by DHS should any concerns regarding the safety of the technology come to light. And we will also have a limited term not to exceed a reasonable period for testing or evaluating the technology. Typically we go around 36 months, but it's really technology by technology with this. Further, the Safety Act liability protections associated with the DTED will apply only to acts of terrorism that occurred during the period set forth in the particular DT&E designation. In certain circumstances, the department may find that the technology being evaluated for designation, it might not be mature enough for that level of coverage. In that event, the applicant may be awarded a developmental testing and evaluation designation. However, additional requirements might be associated with that special designation, such as submittal of formalized test plan or a proposed test location to our office, the Office of Safety Act Implementation. Thus, an applicant may be required to resubmit a formal DTED application. So that happens sometimes. We look at an application, we think it needs a little more work, and then this is the path we recommend to people to take.
Okay. Well, I think now that we've described what the protections mean for you, we're going to talk a little bit about what they mean for your customers and your subcontractors. What should you tell them? I think that's an important thing that folks struggle with, right? I have the protections, but there's benefits for other people. So we've mentioned before that along with your protections, there's responsibilities. So what does that mean to you? So there's some things you need to tell DHS before we get to your customers, in addition to maintaining your liability insurance. So depending on the type of protections you have, you may need to be in contact with us throughout your designation. So for example, if you have a DT&E designation, you will probably have to tell us about your deployments, maybe who they are, where they are, and who they're providing the technology to. But if you have a full designation with no special considerations or limitations, maybe we won't need to hear from you, which is kind of sad, until it's time for your renewal. We actually do like to talk to you guys as you're deploying things. So keep that in mind, that throughout our discussion we have this evaluation process. And that's actually one of the things you can tell your customers, that someone who's outside of your process and who's independent, either a technical or a legal or a financial expert, has looked at your technology. And that review considers your technology's history, your deployments, your performance, and the safety of your technology. But just simply by the receiving of designation, certification, or DT&E designation, you know, and you can let your customer know that external evaluators have determined that your technology can be effective, right? That's a big deal. So be proud of that, right? You can be proud of your Safety Act protections, and that's one of the things you should be able to tell people. And so I think actually that's the segue to our next slide. What do you tell everyone after you've gone through this?
Yeah, that's right. And I think, you said be very proud. We think the Safety Act is a big deal. Obviously we do, we might be biased, but you should think it's a big deal too. And that's why we created the Safety Act trademarks, or the Safety Act marks. As a designated or certified technology, you can use those Safety Act marks. You've seen them already, scattered all throughout this webinar. They are an important part of letting your customers know about the protections you've received. As I mentioned earlier, we go to a lot of conference and trade shows. Excuse me, we always like to see the marks being used for technologies that we've already approved. You can use them on your website. You can use them on your posters and brochures. You can use them in your marketing materials. Again, your technology has been independently evaluated and was shown to have merit. That is something to be proud of. There are some limitations to using these trademarks. It cannot be used for other technologies that you provide that have not been designated or certified. That should be kind of obvious, but sometimes it happens. We want to make sure that we're clear. The marks should only be associated with the technology or technologies that OSAI has reviewed and awarded liability protections for. Please also note that it does not include the right to use the DHS seal. These marks cannot be used to endorse your technology over your competitors. This review is not a comparison, but the award shows that you've demonstrated that the technology meets 5 technical and 2 economic designation criteria: deployment history, availability, capability, effectiveness, risk to the public, extraordinarily large or unquantifiable exposure to third-party liability, and substantial likelihood to the technology will not be deployed without Safety Act protections. Those are our criteria. So let's just make sure that when you use the mark, it's clear what you've achieved.
Yeah, and I think people have achieved a lot. So we talked a little bit before about this upstream, downstream parts of your supply chain, and I want to get back to that. And we're going to go back to Meenal for a discussion of what the protections apply to suppliers and vendors and subcontractors. So Meenal, let's talk about flow up, I guess, through the seller first.
So this concept is connected to our previous discussion about exclusive jurisdiction. As we were discussing earlier, the only defendant in a lawsuit as a result of an act of terrorism under the Safety Act is really the seller for the performance or non-performance of their technology. In the past, suppliers and other upstream vendors were exposed to litigation by simply being involved in a specific supply chain. The Safety Act essentially helps manage this litigation risk by clarifying that only the seller of the technology may be sued for claims related to that performance, non-performance of the technology. The protection that is intended to flow up is protection against being sued, essentially. I'd like to take the moment, though, to state that the Safety Act hasn't been tested in court, and therefore I don't have any specific cases or instances that I can discuss where the concept has been applied by a judge. That being said, I again urge you to, seek out your in-house counsel, develop a dialogue about the Safety Act program, because this affects the in-house counsel offices and the risk management offices in your individual organizations as well, and have some frank discussions about how the statute may specifically protect your company as well as your upstream suppliers that do business with you, and how you can market that and package that so that you can talk to your upstream suppliers about this.
Great, thanks, Meenal. So that's upstream, and then there's downstream. So what's downstream?
So again, similar to upstream protections, your downstream customers and distributors are also protected from lawsuit for any claims related to your specific technology. But here, I have a specific example I can give you, kind of based on your technology. So first, the protection for the lawsuit, protections from lawsuits is for claims related to your technology. So let's take an example. If your technology is a metal detector, then your customers and distributors are protected against claims associated with the performance or non-performance of that metal detector. If one of your distributors provides the metal detector and also operator training on the metal detector, the distributor is only protected for the metal detector, but may not be protected against claims associated with that operator training that they provide. If your customer provides an operator to operate that machine, then your customer may be exposed to any claims associated with the negligence or mistakes of that operator in the operation of that machine. So if you, as a seller, provide the metal detector, the training, and the operator, and the operator to your customer, and you receive Safety Act protections for all 3 of these components of your technology, the machine, the training, and the trained personnel, then your customer would be protected from any claims related to these 3 components. So that would be how you distinguish the flow down liability protections.
Great. Thanks, Meenal. Now that everyone out there hopefully understands some of the legal aspects of protections for customers and suppliers, what's the best way to tell them about these protections? I mean, I go back to that example that we used before, right? If the seller is making that walk-through metal detector, you just got your Certificate of Safety Act designation, and now you want to tell the world, right? First, you go to a stadium operator who uses your metal detector at the entrances. And in this case, the stadium is my customer, right? Okay.
Yeah.
And so if the metal detector is used for an event or a game day and a terrorist tries to smuggle in a concealed weapon or does something, then the metal detector maker is sued, not me as a stadium owner, right?
To a certain extent.
Okay.
So if the claims are for the metal detector, then the metal detector maker will be sued. However, if there are claims that the stadium did something that they shouldn't have, and that's not within the protections of the metal detection maker's Safety Act protections, then the stadium may also be liable for some of that.
All right, so then my supplier's and vendor, right? I'm again the maker of this walk-through metal detector.
Mm-hmm.
I don't manufacture the components in my facility. Instead, I buy chips and switches and all sorts of things from an electronics guy. How do the protections help the vendor then, or the supplier?
Well, then, in that case, the Safety Act is intended to protect those upstream suppliers of the individual component parts that go into the
All right.
product itself.
So the seller and the maker of the metal detector are the only defendants then, right?
Yes.
Okay.
Probably, presumably, as this has not been tested in court.
Okay. All right. So what if I make the metal detectors, but I don't install them because I'm located in only one city, right? I'm here. I can't be in San Francisco right now. I might use an installer. What does that mean?
So in that case, if your company received Safety Act protections for both the metal detector and the installation process, then your subcontractor for that installation would be protected. But it is dependent on what the scope of your Safety Act protections were.
Okay. So really, by getting Safety Act designation and certification, you're protecting your customers, your suppliers, your vendors, your subcontractors, and other partners in your supply and distribution chain from these third-party claims, just depending on the circumstances. So once I have these, I should really tell them and try and explain them about them. Is there anything else I've missed as I've tried to put you on the spot here, trying to answer some of my more questions?
No, I think I just want to reiterate that the only thing that the upstream and the downstream protections really rely on the technology that receives Safety Act protections. So let's take that last example that Laura had, the maker with the subcontractor and the installation. If both the installation and the maker receive Safety Act protections, then they would both be protected, and only the maker would probably have Safety Act litigation.
Okay. All right. So I guess that really means, however, if the Safety Act protections are only the metal detector, then your subcontractor, right, wouldn't have coverage for the installers. Do I finally have that right?
Say it one more time, I'm
okay.
sorry.
So I've got the maker. I'm the maker of the metal detector, and I have my subcontractors. My customer, who's an installer, wouldn't necessarily have coverage down here, right? It's only through me.
Yes.
Okay.
Yes.
Got it. All right. This is very informative. 10 years. I'm learning so many great things. So I think, Andrea, what do you got else for us?
I got a little bit more, and I got to say, while you were both talking, I was listening, and I'm reading some of the questions coming in on the left-hand side, too. So if my eyes are all over the place, that's why. But I'm looking forward to some of the questions that they're asking, so that's good. Okay. So now that we've covered all these protections, we need to talk about the responsibilities that go hand in hand with these protections. You, the seller, have a responsibility as well. When you've received your Safety Act letter, you need to provide 2 pieces of information to our office right away. First, you need to certify your liability insurance and tell us about it. Then you need to review the terms and conditions for using the Safety Act marks, sign the document, and submit it back to us. We have to have that signed document in order for you to legally use those marks. Further down the line, you may make changes to your technology. It happens all the time. We hope that as threat environment changes, you're looking at your technology and making updates. We need to know about those changes, especially if it changes the scope of the designated technology. There are a few other things that you might need to inform DHS of, such as adding a licensee or transferring your Safety Act protections, if there's a sale of the company or something like that. Certifying your insurance. Okay, so Safety Act designations and certifications require sellers to obtain and maintain a certain level of liability insurance that would respond to third-party claims arising out of an act of terrorism. Sellers should certify that they will carry such insurance within 30 days of receiving your Safety Act protections. The first thing you should do when you obtain your Safety Act designation and, as applicable, certification is certify that insurance. Review the section in your designation letter called the Liability Insurance Required. This section is typically on page 2 of the letter that we're going to send you, and the amount is very specific to your company. Every letter has something different. You certify your insurance by logging on to www.safetyact.gov and submit a signed statement on your company's letterhead, confirming that you meet the insurance requirement specified in your designation letter. We suggest the following language. Okay, it's going to be a mouthful. I hope everyone's ready. Pursuant to Section 25.5H of the regulations, seller name hereby certifies that it will maintain the insurance required in the Certificate of Safety Act designation. Dated date designation was issued, so whatever the date is in the letter, concerning the above referenced technology.
All right. And I think we put that up on the screen so people
Yeah,
can
so
copy
you
that
can
down.
read it there
so
too.
people download the slides, right?
I know.
Yeah.
Download them, and it's probably in the
Use
letter
it,
as well.
yeah.
You could probably just copy and
it in.
paste. Okay, returning the usage agreement to us, it's just as easy. After you receive your certificate of designation, you're going to receive Safety Act designation mark usage agreement. Write the name or names of the seller. We mentioned earlier there might be multiple sellers, and the technology name in the form. Now this is important. Write it in pen. Please don't type it or add it electronically. We need it handwritten. Sign the document. The signatory must be a legal representative of the company, the seller, not an outside preparer or outside legal counsel. Scan that document, upload it to the Safety Act website, and you're all done. It's just that easy. But it's important to make sure that it's done, and it's important to make sure it's done correctly.
Yeah, excellent, thanks. So one other easy thing to do, I mentioned that we do like to hear from you, so keep us informed about changes to your technology. We want to know what's going on, so we have this modification mechanism on our website. Sellers can request that the department update your designation and or certification if there's been a change to your technology, or to, maybe you've started a new subsidiary who's selling it, you've acquired a company. So if there's changes to the sellers, we need to know that too, right? Because remember, only the sellers listed have those benefits we've been talking about. So we recognize that maybe you make changes in manufacturing or installation or implementation, component assembly, or in just other things. These happen, right? This is how business works. If the modifications you make, though, or intend to make, are more than these types of routine changes and are potentially outside the scope of the technology approved for Safety Act protections, then it's really important, right, for you to notify us through a form that's called a Notice of Modification of Qualified Anti-Terrorism Technologies, right? Again, your Safety Act coverage applies only to the technology as described in part of this package you get from us called Exhibit A, and it's attached to your Certificate of Safety Act. So when you're not sure, right, if something's going to take you out of the scope of that Exhibit A, certainly just give us a call, right? We walk through these things with applicants all the time. And then, we can use this form also for modifying your insurance. Things might have changed. So we can look at your insurance requirements again sometimes. So, even though your technology is undergoing modifications, you need to make sure that it's sufficiently similar to the technologies that's approved, because you want those Safety Act protections to hold up. So if the original evaluation and approval of Safety Act protections are not directly applicable, and you've got a new product or a service, you might need a new application, right? But we want to talk through these things with you to make sure you have that constant coverage. So for modifications, we would typically see 4 types, just to touch on. They're administrative, they're technical, they're economic, or some combination, because we always have combinations. So an administrative request, if you're thinking about those, they might be clerical or other corrections. Technology modifications could include addition of new models or new services or a product line, or maybe an expansion of, I was selling in aviation and now I'm selling in the different commercial space. So maybe I needed to look at that. Maybe there was a revision of the standards I'm employing or protocols I'm using that I want DHS to take a look at. Economic modifications are interwoven with changes and sometimes deal with corporate restructuring, revisions of third-party liability coverage requirements, and again, this addition of new sellers. If a seller is not listed, they're not covered. So I think that's my big point. Mino, I don't know if you have anything else to add in the context of modifications.
So I think the only thing I would touch on, and it's to emphasize that if you're thinking about submitting a modification and you're just not sure whether it's a modification or a new application or where you are, just call our offices. Really reach out to us and we can work through it and we can tell you which path would be the best path to pursue.
Okay, great. And I think that builds on our next concept and one of our fundamental concepts here, I think, in the Office of Safety Act implementation. Anytime you get stuck, you can ask for help. We're small, but we really love working with industry and we'll do our best to quickly accommodate requests for help. There's a couple ways to do that, and there's a couple ways to get help, and I know they're on the slide. So please make sure you're taking advantage of them. There's our pre-application processes where you can talk to us in advance. There's web resources, right? We've got our webinars and we've got some briefings and we've got a whole list of frequently asked questions, right? They're up there because they've been frequently asked. So a lot of people are thinking about things and they might have value when you're troubleshooting your submission. There's, you know, our help desk, our phone number, please give us a call. Because I think that helps a lot always.
Yeah, we would rather answer your questions ahead of time than have you do a lot of work and now you're stuck. So let us help you. So I think we're about to take some questions, and actually I don't know if we can go back to the last slide because it's more informational than just having the DHS thing up there for folks. As you start working through your Safety Act things, I'm repeating what Meenal and Laura said. Just remember you can reach out to us either through the website, the help desk email address, or through the phone number that's listed there. So anyway, I mentioned earlier there were some really good questions on the left-hand side. I did not keep up with what was already answered and what wasn't. So I don't know if our team can help us with that. And also we'd like to open the line up for questions as well.
Yeah.
So if the operator could please make an announcement about the process for that, Kathy, that would be helpful.
Sure. At this time, if you'd like to ask a question via the phone, you may press star followed by the number 1. Please remember to unmute your phone and record your first and last name clearly when prompted. One moment, please, as we wait for questions.
Sure. While we wait for questions, when you registered, there was an opportunity for you to ask some questions, and we looked through these yesterday. I think we answered a lot of them already through our discussions, but just a couple simple ones. One person asked about a certificate after taking this course, and I think we really are not looking at this as so much as a training course as we're just trying to be informational. So unfortunately, there's not a certificate available. You can download the slides, though, as Laura mentioned earlier, after we're finished. Another question was involving grants or incentives. I think that Meenal's examples of the immeasurable liability incentives was a great overview of the incentives. And I think that Laura touched on grants earlier, and the fact that the Safety Act is not associated or tied with any specific grant program. So there are grants available out there. I know that FEMA provides grants and other agencies provide grants, but the Safety Act is not associated with any grant programs.
Yeah. Kathy, is anybody hanging in there on the line?
No, at this time there are no questions in the phone queue. Once again, if you'd like to ask a question through the phone, just press star 1 and record your name.
All right.
So while we do that, I don't know if it was answered on the left, but one question when we talked about the marks and the authority to use the marks, one person asked a question about why can't I use the DHS seal, that they saw the DHS seal being used on something that was associated with a FEMA project. And it's not directly in front of me, so I can't read the question verbatim, but perhaps, Meenal, you can touch on the use of the DHS seal for us.
So I actually, I can, but I can probably provide a lot more information in writing to the specific person if we can get their contact information at all. But the DHS seal is very tightly controlled, and it's for obvious policy reasons. We do not want the seal to be used in a negative manner or just out there to be used by anybody. Just like corporate entities who are very protective of their logos and how those logos appear in the public eye, we are very protective about how the DHS seal appears in the public eye. And so there are options to use the DHS seal, but they are very tightly controlled by a specific office. I think it's the Office of Public Affairs for DHS. in terms of who has authority to display that seal. And that goes for movie productions, that goes for games or anything like that where they want to use the DHS seal.
Okay, that was really great. There's another question here. About the Safety Act not being tested in court to date. To date, there has not been. Oh, 'cause that looks like it was answered already. Are there any questions on the line yet?
There are no questions in the phone queue.
All right. Well, I think if there's no question, we'll leave the chat room open for a little bit longer, but I think we're pretty much used up our hour.
Yep.
So I think we'll be back after the first of the year with the beginning of our 2016
Right,
series.
so let me just briefly say, we have a lot of applicants, maybe you're on the line now, who are ready for renewal. It was a big year for us. 5 years ago, we had a lot of applications, and so we're anticipating a lot of people working on renewal applications over the next 12 to 24 months, and so we'd like to help prepare you for that. So our next webinar will be when it's cold outside, January, February, and we're going to be talking about the best ways to prepare a renewal application. So look forward to you talking about that in our next webinar.
Great, and since this is the last time we'll be talking to you, our industry partners, this calendar year, we wish you and your families all the best in this last month of 2015. Be safe and Happy New Year.
All right, thank
Thanks.
you.
Thank you, everyone.